Legal and Privacy Brief for July 16, 2026. 23andMe settles with 42 states for $18 million over a 2023 data breach, exposing 6.9 million users' genetic data. Block Inc. pays $45 million to 46 states for misleading Cash App users about fraud protections. California steps back from expanding its age-gating law to browsers and websites, reducing threats to online anonymity. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, July 16, 2026. Next section, Enforcement Actions. 23andMe reaches $18 million settlement for cybersecurity failures. A coalition of 42 state attorneys general secured an $18 million settlement with 23andMe for cybersecurity failings that led to an October 2023 data breach, exposing 6.9 million users' genetic ancestry data. The company had no protections against credential stuffing attacks, insufficient intrusion prevention measures, failed to log or monitor for breaches, and did not fix known vulnerabilities. 23andMe initially denied the breach occurred and later blamed consumers for password reuse. The settlement requires the 23andMe Research Institute, which acquired the company's assets in July 2025 for $305 million, to undertake risk assessments, appoint a special board for data security oversight, and maintain users' right to delete genetic samples and personal data indefinitely. Compliance action, review genetic and biometric data handling practices, implement credential stuffing protections, continuous monitoring for atypical login patterns, and regular vulnerability assessments. Document user rights to data deletion in privacy policies. Sources: The Record. Block Inc. pays $45 million over Cash App fraud protection claims. Block Inc. agreed to pay $45 million to resolve allegations by 46 state attorneys general that it misled consumers about Cash App's safety and fraud protections while failing to adequately protect users from fraud. The multi-state investigation found Block made representations about refund protections and customer support while allegedly failing to deliver promised fraud protections and dispute resolution. The consent judgment addresses allegations related to account locks, account suspensions, fraud communications, and compliance with the Electronic Fund Transfer Act and Regulation E. Block must maintain 24-hour telephone support for fraud complaints and educate consumers about common fraud schemes. Block denies wrongdoing and states the agreement resolves a legacy matter primarily relating to historical aspects of its business. Compliance action, review payment app fraud protection claims against actual capabilities. Ensure customer support channels are accessible 24/7 for fraud complaints. Verify Electronic Fund Transfer Act and Regulation E compliance for dispute resolution processes. Sources: Top class actions. Next section, Litigation Updates. Temu faces California class action over deceptive spam emails and tracking pixels. Case No. 2 to 26 CV 5657, Dallas Potash filed a class action complaint against Welico Inc., doing business as Temu, in California federal court, alleging violations of California's anti-spam law and trap and trace law. The complaint claims Temu sends spam emails with misleading subject lines, such as $0.1 false nails and soon, forged headers and spoofed domains including private URL. Appellate.com to obscure sender identity. After recipients click links and visit Temu's website, the company allegedly installs tracking pixels that monitor online activity and collect personal data without consent. California's trap and trace law requires companies to obtain a court order before installing devices that capture routing or signaling information from electronic communications. Potash seeks statutory damages of $1,000 per spam email, plus punitive damages and injunctive relief on behalf of all California citizens who received spam emails from Temu or had their data collected without consent. Compliance action, review email marketing practices for compliance with California's anti-spam law. No falsified headers or misleading subject lines. Obtain explicit consent before installing tracking pixels or other monitoring technology. Verify compliance with California's trap and trace law for any routing or signaling data collection. Source: Top class actions. Stasi data breach class action settlement reaches $2.95 million. A $2.95 million class action settlement has been reached for individuals affected by the Stasi data breach. Class members who were affected by the breach may be eligible for cash payments from the settlement fund. Compliance action, review data breach notification and settlement processes. Ensure breach response plans include timely disclosure and appropriate remediation funding. Source: Top class actions. Popflex and Redo Tech sued over hidden return fee dark patterns. Case No. 8 to 26 CV 597, Madison Bakerch and Crystal Kagoy filed a class action in California federal court against O Gorgeous Inc., Popflex, and Redo Tech Inc., alleging violations of state consumer protection laws. The complaint claims Popflex automatically adds a $2.18 checkout plus unlimited returns or exchanges fee without knowledge or consent, displaying it in small text below the subtotal rather than as a cart item. Customers must click a faint link reading, continue without checkout plus, to remove the fee, which plaintiffs allege is designed to make shoppers think they would abandon checkout entirely. In Popflex's mobile app, a toggle next to unlimited returns or exchanges defaults to on, but switching it off does not remove the fee, which reappears at checkout. The FTC, the Federal Trade Commission, defines these design practices as dark patterns that trick or manipulate users into choices they would not otherwise make. Plaintiffs seek damages, restitution, and injunctive relief for a nationwide class and subclasses in California, New York, and Utah. Compliance action: review checkout flows for FTC dark pattern compliance. Ensure fees are clearly disclosed as line items in shopping carts, not hidden below subtotals. Verify that toggle switches and removal options function as indicated to users. Source: top class actions. Cove USA accused of running perpetual fake sales. Case No. 8 to 26 CV 789, Russell Leach filed a class action against Cove Surf Co., Inc. in California federal court, alleging violations of California's false advertising law, Consumers Legal Remedies Act, and unfair competition law. The complaint claims Cove runs perpetual sales with fabricated urgency, including a limited 24HR flash sale that reset nightly and continued for nearly 4 weeks. Wayback Machine Archives confirmed fake sales ran for more than 3 months. California's false advertising law bars advertising former prices not prevailing in the 3 preceding months. The complaint also alleges Cove rebranded the same discount as multiple separate sales. December 2025 holiday sale became January 2026 New Year's sale, then March 2026 spring sale. Plaintiff seeks damages, restitution, and injunctive relief for all U.S. consumers who purchased products advertised at a discount on Cove's website within the applicable statute of limitations. Compliance action: review sale pricing and advertising claims for compliance with California false advertising law. Ensure reference prices reflect actual prevailing prices within the preceding 3 months. Eliminate countdown timers that reset without genuine limited time offers. Source: top class actions. Supreme Court ruling on Bruin test survives in United States v. Hemani. The Supreme Court unanimously sustained Ali Hemani's challenge to his indictment under 18 U.S.C. Section 922 G3 for possessing firearms while being an unlawful user of a controlled substance. Justice Neil Gorsuch's opinion subjects the government's historical evidence to exacting scrutiny, rejecting claims that the law is consistent with founding-era vagrancy laws. The decision confirms the Bruin test from New York State Rifle and Pistol Association v. Bruin 2022 remains the standard for Second Amendment challenges. Challengers must show conduct falls within the plain text of the Second Amendment. Then government must prove the law is consistent with the nation's historical tradition of firearm regulation. The court dissected the how and why of founding-era regulations, finding they targeted individuals who did not meet societal expectations of work, not categorically violent persons. Section 922 G3 remains on the books but cannot be applied without proper historical analogs. Compliance action: organizations subject to ATF regulations should review firearm prohibition policies for historical justification under Bruin. Consult legal counsel before denying firearm rights based on substance use absent individualized dangerousness findings. Source: Scotto S. blog. Fifth Circuit vacates due process ruling for migrants. Reheard en banc, the Fifth Circuit vacated its July 2, 2026 panel opinion recognizing due process rights for migrants detained longer than 90 days and ordered the case reheard en banc. The original panel decision found that migrants arrested long after crossing the border have access to due process rights, but only after 90 days in custody. A majority of circuit judges voted to rehear the case, likely signaling an intent to eliminate even the 90-day delay before due process protections apply. The administration has been relocating detained migrants to Fifth Circuit jurisdictions, Texas, Louisiana, Mississippi, to prevent constitutional challenges during the 90-day window. Source: TechDirt. Federal judge rules Rubio State Department engaged in censorship by denying visas to disinformation researchers. A federal court ruled that the State Department's policy of denying visas to people who work in misinformation/disinformation research, content moderation, fact-checking, or trust and safety roles constitutes unconstitutional viewpoint discrimination. Judge Boasberg held that the policy punishes researchers for their own speech and association regarding disinformation research. The court noted that only government officials, or those working directly at the behest of government, can engage in censorship of protected expression, while private parties use their own rights of association to determine what content they wish to associate with. The plaintiff organizations' work depends on researchers who study how platforms structure public debate, report on misinformation, advocate for platform data access, and collaborate to set standards. The policy impairs CITR's ability to determine who will contribute to its reports, what reports can say, who will attach their names, and whether researchers will participate in convenings. Compliance action. Document that content moderation and trust and safety work is conducted based on private editorial discretion, not government direction. Maintain records showing independence from government influence in moderation decisions. Source: TechDirt. Supreme Court shadow docket decisions now outnumber Merit's docket pro publica analysis of over 2 decades of Supreme Court rulings found that, when the last term ended, justices issued 63 orders on the shadow docket versus 56 orders on the Merit's docket, where oral arguments are scheduled months in advance, and justices issue signed opinions. This marks the first time in modern history that so many consequential decisions were made by secret ballot with few signed opinions. These emergency decisions have thrown lower courts' processes into turmoil and sometimes directly contradicted longstanding legal precedent. The court has used the shadow docket to limit federal courts from issuing nationwide injunctions, diminish Congress' authority over federal agencies, and allow detention of American citizens by immigration agents. Legal scholars state the patterns show a court enabling Trump administration policies that lower courts have blocked, with little to no explanation. Compliance action. Monitor shadow docket orders for emergency stays affecting regulatory compliance obligations. Do not assume lower court injunctions provide compliance safe harbor when shadow docket intervention is possible. Source: TechDirt. Next section, regulatory guidance. Trump administration announces Gold Eagle Cyber Vulnerability Clearinghouse. The Trump administration announced Gold Eagle, an operative federal clearinghouse housed in the Treasury Department, allowing industry, critical infrastructure operators, and government to use artificial intelligence to rapidly detect, prioritize, and patch cybersecurity vulnerabilities. The clearinghouse uses AI, including Anthropic's Mythos model, to detect and fix vulnerabilities at unprecedented speed and scale, enabling vulnerability discovery at levels not seen before. Gold Eagle deconflicts resources, validates vulnerabilities, and coordinates triage among industry and government engineers. The effort is made possible by the CISA, the Cybersecurity and Infrastructure Security Agency, 2015 Act, which expires in September 2026. Administration officials stated that without congressional reauthorization, the effort is fundamentally challenged. Carnegie Mellon University's Software Engineering Institute built the intake platform. The clearinghouse also facilitates a vulnerability information and coordination environment, VINCE, for processing, secure sharing, validation, prioritization, and disclosure of vulnerabilities. Compliance action. Monitor for congressional reauthorization of CIS, a 2015 Act, by September 2026. Prepare to integrate Gold Eagle vulnerability feeds into patch management processes. Coordinate with Treasury Department and CIS on clearinghouse participation. Source: the record. NYC implements click-to-cancel rules, and junk fee ban. New York City Mayor Zoran Mamani announced Executive Orders 9 and 10, which ban all hidden junk fees and implement a click-to-cancel rule guaranteeing consumers can cancel subscriptions as easily as they sign up. The rules follow the Biden FTC's 2024 click-to-cancel rules, which were blocked by the 8th Circuit Court of Appeals before taking effect, and are advised by former FTC Chair Lina Khan. The orders require that if a service can be signed up with one click, it can be canceled with one click. Enforcement will be critical, as states and municipalities often announce such rules but fail to engage in costly and time-consuming enforcement against deep-pocketed companies. Compliance action. Businesses operating in New York City must ensure cancellation processes match sign-up complexity. Remove multi-step cancellation flows if sign-up is single-click. Prepare for potential municipal enforcement actions. Source: TechDirt. Next section, privacy developments. California legislature removes browser and website age-gating expansion from AB 1856. The California legislature stepped back from expanding its age-gating law AB 1043 to browsers and websites, removing the most problematic language from AB 1856. The underlying law AB 1043, signed in 2025, effective January 2027, requires operating systems and app stores to collect users' ages, place them in age brackets, and block young people from lawful speech and services based on age. The law fines operating systems up to $7,500 per affected child for violations, creating liability that will likely push services to verify users' ages through ID checks, biometric scanning, and invasive data collection. B. 1,856 amendments exempted open-source operating systems and removed the expansion to browsers and websites. EFF removed its opposition to AB 1,856 following these changes, but maintains that B. 1,043 remains unconstitutional as it threatens online anonymity, privacy, and security by encouraging age verification systems that link offline identity to online activity. Compliance action. Operating systems and app stores subject to AB 1043, effective January 2027, must prepare age collection and age-gating mechanisms by year-end. Document age determination methods that minimize invasive data collection. Open-source operating systems are now exempt. Source: EFF deep links. Most wearable health devices lack transparency reports and end-to-end encryption. EFF research found that only 2 of 10 major wearable health device companies, Apple and Google/Fitbit, publish transparency reports on law enforcement data requests. Only these 2 companies, plus Whoop, promise to notify users of law enforcement requests. Aura updated its privacy policy in June 2026 to notify users of requests and stated it is actively evaluating transparency reports. Surveys suggest around 40% of people in the United States own wearable health devices that collect abundant data with no special health-related privacy protections. Companies share data with third parties for marketing or to influence insurance rates, or use it to train artificial intelligence models. Wearable data has been critical in law enforcement cases, with surveillance company Penlink calling fitness trackers an overlooked source, showing movement patterns and heart rate changes. Law enforcement accesses this data through subpoenas or warrants. Few companies offer end-to-end encryption, preventing the company itself from accessing health data. Compliance action. Health and fitness app developers should publish transparency reports detailing law enforcement data requests. Implement user notification for government data requests when legally permissible. Evaluate end-to-end encryption options for health data to eliminate company access. Source: EFF deep links. Sony deletes 551 purchased movies and TV shows from PlayStation Store accounts. Sony removed 551 films and TV series from PlayStation Store customer accounts on September 1 due to licensing agreement fallout with Studio Canal. This marks the 3rd major content deletion incident. 2022, German and Austrian users lost hundreds of movies. 2023, American users lost hundreds of TV episodes after Warner Bros. Discovery merger. No refunds are provided. Sony's terms and conditions state purchases are temporary licenses for an undetermined time period, but the company does not prominently disclose this limitation, and most customers believe they are buying permanent ownership. The announcements treat content deletion as routine with no apology or compensation. Compliance action. Digital content platforms must clearly disclose that purchases are licenses, not ownership transfers. Distinguish buy buttons from license or rent buttons. Consider refund policies for license terminations beyond customer control. Source: TechDirt. Next section, policy changes. Congress advances KIDS Act age-gating package. The House of Representatives passed the KIDS Act, a package of proposals to control what users can see and say online. Supporters claim the act is needed to protect minors, but the legislation encourages more surveillance instead of protecting privacy. EFF warns that if the KIDS Act becomes law, it will threaten the open internet by mandating age verification and content restrictions. The act represents congressional efforts to age-gate the internet following state-level initiatives. Compliance action. Monitor KIDS Act progress through Senate. Prepare for potential federal age verification and content filtering requirements if enacted. Evaluate technical and privacy implications of age determination systems. Sources: EFF deep links. Trump administration asks Supreme Court to reconsider temporary protected status for Venezuelan and Haitian nationals. U.S. Solicitor General D. John Sauer urged the Supreme Court to order the Ninth Circuit to reconsider its ruling blocking then DHS Secretary Kristi Noem's decisions to end temporary protected status. TPS, designations for Venezuela, designated 2021, redesignated 2023, extended through October 2026, and Haiti, designated 2010 after earthquake. The Ninth Circuit upheld U.S. District Judge Edward Chen's order setting aside the termination decisions. the Supreme Court's ruling in Mullen v. Doe held that courts generally cannot review the Secretary of Homeland Security's decision to designate or terminate a country under the TPS program, barring review of non-constitutional claims. Sauer argues the Ninth Circuit should reconsider based on Mullen and presumably reverse its relief for Venezuelan and Haitian TPS beneficiaries. Challenger's response is due August 12, 2026. Source: Scotto S. blog. Next section, Compliance Takeaways. Genetic and biometric data handlers implement credential stuffing protections, continuous login monitoring, regular vulnerability assessments, and intrusion prevention measures before the next breach, not after. The 23andMe $18 million settlement demonstrates state AGs will pursue companies lacking basic cybersecurity controls. Payment platforms and fintech apps review fraud protection marketing claims against actual capabilities to ensure Electronic Fund Transfer Act and Regulation E compliance. Block Inc. $45 million settlement shows states will enforce consumer protection requirements for refund processes and 24/7 fraud support. E-commerce and subscription services audit checkout flows for FTC dark pattern compliance by Q3 2026. Remove hidden fees displayed below subtotals, ensure toggle switches function as indicated, and verify cancellation complexity matches sign-up complexity, especially for NYC operations. California false advertising law requires reference prices to reflect actual prices within the preceding 3 months. California operating systems and app stores prepare for a B. 1,043 age gating requirements by January 2027 deadline. Implement age collection and age restriction mechanisms, but minimize invasive data collection to reduce breach risk. Open source operating systems are exempt following AB 1,856 amendments. Wearable health device manufacturers publish transparency reports detailing law enforcement data request volumes and types. Implement user notification for government data requests when legally permissible. Evaluate end-to-end encryption deployment to prevent company access to health data and reduce subpoena exposure. That concludes today's legal and privacy brief from Carolina Clear Tech. For informational purposes only, not legal advice.